This podcast explores the workings of the criminal justice system, including the investigation and prosecution of serious offences involving sexual and physical violence. Episodes may contain detailed and sometimes graphic accounts drawn directly from case files, witness testimony and court proceedings, including those involving adult and child victims. Listener discretion is advised. This is Episode 4 of Criminal Justice in Action, Season 1, Rape on Trial. If you're a new listener, hello, welcome. I'm delighted you're here, but I'd strongly recommend you go back to at least Episode 3 to hear the first half of the trial we're watching, or better yet, start with Episode 1. This isn't a dip in and out at will type of podcast. The cases discussed and the themes and the issues that they raise, well, they emerge over multiple episodes. For returning listeners, welcome back. Here's where we left Jerome's trial in Episode 3. Jerome's on trial for 5 robberies and 1 rape. When the trial started, Jerome was denying all the charges on the straightforward basis that it wasn't him. After the Crown's opening speech and the CCTV preview, he changed tack. He now admits being in the rooms and taking the complainant's money, but he denies using or threatening violence, having any weapons or any sexual contact with any of the complainants. So he's basically saying theft, not robbery, and no rape. Because identity is no longer disputed, because the issue's now what happened in each of those hotel rooms, the evidence of all 5 complainants needs to be heard. We've already heard from 3, Sophie, Jade and Hannah, each describing a chokehold or a headlock and threats, with Hannah alleging rape and the use of a knife. We also heard a brief statement from Hannah's mum covering Hannah's first disclosure and her distress at the time. That took us to lunchtime on day 4 of Jerome's trial, which is where we paused, and it's where we're going to pick back up today. When we come back into court after lunch, both counsel and the judge are in the midst of a procedural discussion, absent the jury. They're talking about Jerome's previous convictions, which the jury are going to hear about in the form of agreed facts. There's at least 1 robbery charge. We don't know how many or the circumstances around them yet. And there's a previous conviction for false imprisonment and wounding, which the jury's also going to hear about. Was it wounding or GBH, the judge asks. Wounding, says Mr. Palmer. It was multiple stab wounds. The victim was a woman, observes the judge. He wants to know whether further details beyond simply the convictions themselves are going to be given. Mr. Palmer says he and defence counsel are still refining the agreed facts, some of which may not be agreed and may need to be subject to a bad character evidence application tomorrow. With that, the jury's called back in. Once they're settled, the judge tells them they're about to hear the evidence of Natalie, the complainant in count 1. Her witness statement was made the day after the incident, the judge tells them. That statement will be read to you, he says, but it is not agreed. The judge reminds the jury that the defendant doesn't deny his presence or deny stealing from Natalie, but he does deny being violent. He explains that Natalie can't be contacted, so can't be called to give her evidence directly to the court under oath, and she can't be questioned by the defence. You obviously cannot assess her as you've been able to with the other witnesses, says the judge. Mr. Palmer then begins to read Natalie's statement. Natalie's written statement begins by saying she was working as an escort and staying at the Riverside Hotel in City A. A man messaged her at about 3:15 p.m. and made a booking and came straight away to her room. He came across as nice and gentle, she says. When she opened her door to let him in, he grabbed her around the neck, pulled her to the ground. He used such force that I couldn't breathe, she states. When she screamed, he put a pillow over her face. He shouted, "Where's the money?" He didn't just take her money, though. He took all of her possessions, including her passport. He told her that if she calls him tomorrow and gives him all the money she makes today, he'll give her her passport back. As the man went to leave, Natalie says she tried to get up and he threatened her. But when he left, she did run after him. She saw a man in reception and asked for help. Her statement finishes by saying that the man caused her injuries, that the incident lasted over 50 minutes, and by giving a description of the man, including his accent. Next, there's another statement to be read into evidence. It's from the hotel manager at Riverside Hotel in City A. We're going to call him Nigel. Unlike Natalie's statement, Nigel's statement is being read on the basis that it's agreed. In other words, Nigel's evidence isn't disputed by the defence. They have no questions for this witness. So the jury doesn't have to decide whether Nigel's account is true. Both the prosecution and the defence agree that it is. Nigel says that on a particular date, it's the date Natalie says she was robbed, he was working at the Riverside Hotel. One of his maintenance staff, let's call him Jim went to Nigel and said he thought someone was being assaulted. Jim sounded concerned, says Nigel, so we both went up to the room. At this point, he says, there were no sounds of distress, so we left. Soon after, a female went into reception, completely naked. The receptionist informed Nigel, who went to the woman's room. The woman said she'd been robbed and assaulted by a black male. She had visible injuries on her neck and face. I called 999, states Nigel, and made a copy of the CCTV. This isn't the end of Nigel's statement. Instead, his statement moves on to a second date, the date that Sophie was robbed while she was working out of the same hotel, the Riverside Hotel in City A. Nigel was also working that day. He says that on that day, Sophie called reception crying. He, Nigel, went up to her room and he says Sophie was hysterical. She told him she'd been robbed by a man. Nigel advised her to tell the police, but Sophie was terrified. She told Nigel that the man had looked at her documents, knew where she lived, and had told her he'd come and kill her. Nigel says he moved Sophie to another room. I tried to convince her to tell the police, he says. It took a long time. Eventually, she agreed and he, Nigel, called police. Sophie wanted to leave. She wanted to go home, but she had no money because the man had taken it all. Nigel refunded her hotel room and arranged for a taxi to take her to the train station. That's the end of Nigel's statement. Next, another statement, agreed evidence. It's brief. It's from a uniformed police officer. Let's call him PC Smith. PC Smith works for the constabulary that covers City A. His statement says he was on shift the day of Natalie's robbery. He attended a reported robbery at the Riverside Hotel. He met Natalie, who had injuries, which he photographed on his work mobile phone. Natalie told him she's an escort, that she'd been robbed, and that the man had told her to call him tomorrow and give him all the money she made in order to get her other belongings back. While this statement's being read, the jury are looking at the photographs of Natalie's injuries taken by PC Smith. We can't see those photos, they're not on the screen, they're in the jurors' bundles. When the statement's finished, Mr. Palmer plays the full CCTV footage from the Riverside Hotel for the relevant dates. You see the defendant entering, making his way to the rooms, leaving. You also see the moment when Nigel and Jim approach Natalie's hotel room door, wait and listen, and then walk away. We see Jerome leave Natalie's room, shortly followed by Natalie, who runs out of the room naked, and she doesn't stop running until she gets to reception. That's the end of the witness statements to be read in. Mr. Palmer's calling his next witness Jim, the maintenance man from the Riverside Hotel. Jim is neither a vulnerable nor an intimidated witness, so with no special measures in place, we see him enter the court and walk to the stand. He's sworn in, and Mr. Palmer gets straight down to business. On the relevant date, you were working in maintenance assistance at the Riverside Hotel, he says. Yes, says Jim. We see you on the CCTV. Stop outside room XYZ, says Mr. Palmer. Why? I could hear muffled voices, says Jim. It sounded like they needed help. Male or female voices, says Mr. Palmer. Female, says Jim. What made the voice muffled, asked the prosecutor. Like there was something over their face, says Jim. So you stopped at the door, says Mr. Palmer. Did you hear anything? Not at first, says Jim, but then I heard, why are you doing this to me? Describe in one word how it sounded, says the prosecutor. It just sounded not nice. Jim says he thought the female had an Eastern European accent. He says he didn't know what to do, so he'd gone to get the manager, Nigel. They went back up to the room together, but by then it had quietened down. Mr. Dyer's cross-examination is relatively quick and probably quite predictable, so I'll summarise his answers rather than repeat all the questions. Yes, Jim has a master key and can access any room. No, what he heard didn't lead him to take any action. Yes, what he heard concerned him, so he went to get advice. He and his manager Nigel went back to the room together. They were outside the room for a couple of minutes, but they heard nothing of concern, so yes, Nigel had decided to do nothing. Yes, when he went back to work, he found out someone had been robbed, but no, he wasn't aware she was from a foreign country, and no, he wasn't told what had happened. He was just told she was crying. What he was told did not influence his statement to police. No, he hadn't knocked on the door. No, he didn't hear a male voice shouting at any time. No, it wasn't possible that what he heard was coming from another room. Yes, he's sure he heard a voice saying, "Why are you doing this to me?" Mr. Dyer turns to the judge. "No further questions," he says. The judge does have a question for Jim. "You were asked if you heard a male voice shouting," says the judge. "Did you hear a male voice at all?" "No," says Jim. The witness is thanked by the judge and released. The next witness to be called by the prosecution is Detective Constable Sharma. Like Jim, DC Sharma's evidence is over pretty quickly. Sharma's the officer in the case. He confirms with Mr. Palmer that this means he's responsible for the investigation, and he's either taken the witness statements himself or he's asked colleagues to do so on his behalf. DC Sharma also confirms that he'd collected all the information and followed other lines of inquiry, which led to the identification and arrest of Jerome. He'd seized the defendant's 2 phones and gathered the CCTV evidence. He'd asked for 2 Viper identification procedures to be undertaken, which were done independently of DC Sharma. A quick sidebar here. Viper stands for Video Identification Parade Electronic Recording. A Viper's a video compilation, short 15-second head and shoulder clips of the suspect and several lookalikes, and they're all filmed under identical conditions. The witness watches the video and identifies if they recognise the suspect. There are national standards around the conduct of these procedures. The aim is to provide a fairer, standardised, more efficient and less stressful method than the previous process. And the previous process is that live lineup of men in a badly lit room with the witness either marching up and down in front of them or looking at them from behind a mirrored window. The stuff you see on TV and in movies. We don't do that. Back to court, DC Sharma's evidence. Mr. Palmer then takes DC Sharma through the chronology of the investigation to put it in context for the jury. The first person to come forward to police was Natalie. "Yes," says Sharma, "that started the inquiries," and he says that many hours were spent on telephone evidence in terms of traffic and identifying the line. The next incident the police were made aware of related to Sophie. This complaint involved a different phone number. Sophie also went through the Viper procedure and identified Jerome. Jerome's arrested at that point. He was interviewed under caution for 2 hours about the robbery of Natalie and Sophie, and he gave no comment answers throughout. It's the phone evidence that leads police to become aware of Jade, Claire and Hannah. Further statements and evidence is collected in relation to those 3 complainants, and Jerome's arrested and questioned under caution in relation to the new allegations. Again, Jerome gives a no-comment interview. Another Viper is undertaken, this time by Hannah, who positively identifies Jerome. DC Sharma confirms that he's put the CCTV compilation together, and he's put it together on the basis of the defence statement as it was originally submitted in this case, namely that Jerome wasn't the assailant. That's why there's so much footage showing Jerome, because it was put together for use in a case where the assailant's identity was the only issue that was in dispute. That's it. On to cross-examination, which is really, really brief. Mr. Dyer asks only 3 questions. First, whether the various pieces of footage in the compilation are the full available footage or trimmed down versions. They're trimmed-down versions, says DC Sharma, so the jury doesn't have to spend too long watching video evidence. Then, a couple of questions about photographs in cases of violence. DC Sharma agrees with Mr. Dyer's suggestion that such photographs can be used to help, be neutral, or go against the prosecution case. Their purpose is simply to assist the jury. When a complainant is giving their account, says Mr. Dyer, the police can take photos if appropriate to assist the jury. Yes, says DC Sharma. And that's it. Before he leaves the stand, the judge clarifies with Sharma that, having become aware of the two local cases, namely the robbery of Natalie and then Sophie, Sharma had linked those two robberies to Claire's case. Claire was robbed in a different city, in a different county, and was being investigated by a different police constabulary. It was Sharma who identified Jade and Hannah as potential victims and made contact. Sharma did not tell either Jade or Hannah about the other incidents. They were both simply told that they'd been identified through phone work in an investigation, and both disclosed they'd been robbed. When Hannah broke down and told DC Sharma about the rape, he said he arranged for her to be video interviewed as is appropriate in such cases. You never told any victims anything at the time, confirms the judge. No, says DC Sharma. Have you ever? Asks the judge. No, says DC Sharma. The witness is then free to leave, and as it's close to 4 p.m, the jury's sent home. Once the jury's gone, counsel and the judge briefly discuss relevant directions for judges' directions and summing up at the end of the trial. They're discussing the use of previous convictions to show propensity, which is legalese for evidence that shows or suggests that the person, here Jerome, has a tendency to do a particular thing or behave in a particular way. They're also discussing a Section 34 direction, which relates to when and what inferences the jury may draw from Jerome's silence at his police interviews. There's no need for a complex route to verdict, says the judge. If the jury are sure the complainants are telling the truth, they should find the defendant guilty. If they are not sure they're telling the truth, then they should find him not guilty. Court now rises. Day 5 of Jerome's trial, and we're back at court bright and early. Counsel are here, but there's no Jerome. Turns out he's taken ill and can't attend court. The trial's halted as a result. It's another couple of weeks before proceedings resume. When we're back in court, 2 Tuesdays later, there's a problem. Claire, the next witness in the prosecution's case, she didn't realise she needed to come to court today, so she's not here. She hasn't turned up. The judge is very understanding and tells the incredibly apologetic Mr. Palmer that he understands her confusion and doesn't blame her at all. Rather than lose another day, though, Mr. Palmer says the jury can hear Claire's 999 call, a statement from another police officer and the agreed facts. The additional charge, count 7, relating to the firearm, that's not on the system yet, he says, but that can be dealt with later. The jury's called in and the judge explains the situation with the absent witness and that some evidence will be presented today and then agreed facts. Evidence will finish tomorrow, he tells the jury, with speeches on Thursday and deliberations beginning on Friday. Mr. Palmer now stands and tells the jury they're about to hear Claire's 999 call. She was seen going into her hotel room at 7:20, he says. Jerome, who now accepts it was him, is seen to enter the room at 7:22, and he leaves again at 7:35, explains Mr. Palmer. Claire's 999 call was made immediately after that. The audio of Claire's call being picked up by the control room call handler then resonates through the court's sound system. The caller immediately says, I'm an escort and a man's held me up with a gun and robbed me at the Parkview Hotel on XYZ Road in City B. There's been an armed robbery, confirms the call handler. Yes, says Claire. Someone will be right with you, says the call handler. He had a gun? Yes. What did he take? £2,000, says Claire, and my address that was on my driving licence. He made a point of taking your address, says the call handler. Yes, Claire's saying. He said if I didn't give him my money, he'd kill me and my child. Claire sounds frightened, excited, but that feels like the wrong word. She's talking rapidly, but she's clear. She's audibly distressed. You can hear it, and she's tearful. The operator's reassuring Claire now, telling her not to worry, that the fact she's an escort doesn't matter, that it's insignificant in comparison to the crime that's been committed. Claire's calming down a little now, and the operator asks for a description of the gun. She says it was a black handgun. When did it happen, she's asked. 5 minutes ago, says Claire. She's tearful again. She's telling the officer that she found her friend, who's also at the hotel. She came straight to her. She's with Claire now while she's on the call to the police. The police are on the way, says the call handler. Do not worry about the escort thing. It really doesn't matter. She asks Claire for a description of the man, which she gives. Did CCTV catch it, asks the operator. Claire says her friend says it will have, and that the same friend might have seen the man herself when she came up to Claire's room. The operator asks how long he was in the premises, but Claire's getting really upset again now. Her friend comes onto the call. I'm going to move her to my room, the new voice says, in case he comes back. Claire comes back onto the phone now. Did he have a drink or was it a straight in, straight out job, asks the call handler. No, he came straight in and out, Claire's saying. 5, 10 minutes. He touched my bag and put it under the table, but he had gloves on. She's really crying now. Are you all right, says the call handler. It's perfectly normal to feel this way, she says. Remember, you've done nothing wrong. I thought he was going to kill me, cries Claire. I have a baby. Did he take your driving licence, asks the operator. No, he took a picture of it on his phone, says Claire. Luckily, it has an old address on it. Do you have a unique surname if he Googles it, asks the operator. It's quite a unique name, she says. We're going to have officers all over this, says the operator. You will hear sirens. Are you in a place of safety? Yes, she's in her friend's room. That's the end of the recording. Mr. Palmer then reads another agreed statement into evidence. This is from Police Constable Green with the police constabulary that covers City B where Claire was robbed. He states that he's an officer stationed in City B and was on duty. At 19:58, he was dispatched to Parkview Hotel to a report of a robbery at gunpoint. Because there was a gun, firearms officers also attended and were already there. PC Green located Claire, the complainant. She was with her friend. She gave an account that she was working as an escort and advertised her services on an adult website. The offender had called her from a number ending in 1357 and made a booking. The offender said his name was, doesn't matter what he said his name was, and it wasn't Jerome. When the man arrived, he immediately put his arm around Claire's neck and pulled out a handgun. He told her to do as he said and she wouldn't get hurt. PC Green says Claire told him that the man threatened to kill her and her child and took about £1,500. He told her to undress and to get under the bed before he left. PC Green's statement finishes by saying that the firearms officers were already obtaining CCTV footage from the hotel, but that the quality of that footage is poor. That's the end of his statement. Finally, the agreed facts. This, again, is undisputed evidence, some of which assists the jury, some of which is simply procedural formality. Like the first agreed fact, which is that the footage played was compiled by DC Sharma from the hotels involved in each of the counts, and that the footage includes private footage and council footage, and that the times and dates on that footage are accurate unless otherwise stated. It's agreed that John Smith, a radio frequency technician, has plotted one or other of each of the two phones at various locations at relevant times using cell site technology. It's accepted that these times and locations are accurate. Natalie and Sophie reported to City A's police, who then became interested in the use of the 2468 and the 1357 phones. These investigations led them to find the other complainants. Again, in the agreed facts, Jerome was interviewed under caution on 3 occasions. He was represented by a solicitor throughout and answered no comment in each interview. Jerome was invited twice to attend interview in relation to the later counts, those pertaining to Jade, Claire and Hannah, and he declined on both occasions. Searches of property relating to Jerome were conducted. No gun or knife was found. No photograph of Sophie was recovered from either of the defendants' phones. Finally, tucked away here in the agreed facts, are Jerome's previous convictions. He's got one previous conviction for possession of an offensive weapon. He's got 2 previous convictions for robbery. In the first robbery, Jerome attended the complainant's home for paid sex, having contacted the complainant in response to her advertised services. He had consensual sex with the victim, then demanded his money back and punched her multiple times. Jerome's second robbery conviction had the same modus operandi, or MO. He's got another previous conviction for battery, so another physical assault conviction, and he's been convicted of false imprisonment and unlawful wounding. The victim in that case was also female. Claire's non-attendance at court today means that's as far as Mr. Palmer can go with the evidence, so the jury's sent home after another short day in court. Back tomorrow for 10 a.m. The next morning, Claire's in court and she's Mr. Palmer's first witness of the day. She takes the stand just after 10:15. Like all the other robbery complainants we've heard testify, except Hannah, she's giving all her evidence live in court from behind a screen. Claire relays a by now familiar story. She was working as an escort at the time, advertising online and meeting clients in hotels. On the relevant date, she was at the Parkview Hotel in City B when she received a call from a man who made a booking for 7 p.m, meeting in her hotel room. Claire had been downstairs with friends because he was late. When he finally contacted her on her mobile to say he'd arrived, she went up to the room to meet him there. When she opened the door for the man, immediately, and she's very clear about this, immediately, the man grabs her by the throat from behind, puts her in a headlock and forces her to the ground. She's face down on the floor and he's straddling her from behind. He wants to know how much money she's made. She estimates $1,500. Her bags fall into the ground and its contents, including her money and driving licence, have spilled out. Here's where Claire's account differs from the others. Jerome produces what she describes as a small black handgun. He puts on a glove first, then presses the gun to the right side of her temple. He tells her if she's lying about the money, he'll kill her and her family. He sees her driving licence on the floor and takes a photograph of it on his phone. Claire pleads with him not to hurt her or her family. She's got a small child, she tells him. He takes all of her money. He orders her to strip and get under the bed. He tells her to switch off both her phones, her personal phone and her work phone. Then he leaves. Claire waits a couple of minutes to make sure he's gone. Then she turns her phone back on and calls her friend, who's still downstairs. Claire tells her friend what's happened and she comes immediately to Claire's room. She thinks the friend may have passed the man in the corridor on her way up. It was Claire's friend who said she had to call the police. Claire herself just wanted to go home, but she did call. When she spoke to the 999 operator, she told them the truth about what had just happened to her. That's the recording of the 999 call Mr. Palmer played in court yesterday. And that's it. Claire's evidence in chief is done in a fraction over 10 minutes. Cross-examination starts straight away. Mr. Dyer begins by establishing the timeline. Everything happened very quickly, he's saying. Within seconds of entering the room, Jerome grabbed her from behind in a headlock and threw her to the floor. Within seconds more, he was straddling her. Then immediately came the gun, the threats, the demands for money. All very fast, all very shocking. Claire agrees with all of this. It was all very quick. Mr. Dyer then walks through the mechanics of what Claire says happened. She was wearing lingerie when she opened the door. She was thrown face down on the floor. Jerome straddling her, sitting on her waist or bottom area. The gun appeared from his pocket, pressed to her right temple. Bag on the floor, within Claire's sight. Money and driving licence spilled out. From the moment he entered to the moment she was under the bed naked, it all happened very quickly indeed. Again, Claire's agreeing with all of this. But she didn't have any injuries as a result of being grabbed and thrown to the floor, says Mr. Dyer. No, says Claire. Now Mr. Dyer moves on to his challenge of Claire's account. He tells her that Jerome accepts being the man in her room that night. There's no dispute about identity. But, he says, Jerome doesn't accept her version of what happened in that room. Mr. Dyer tells Claire he's now going to put a series of questions to her and her to answer what he, Jerome, says happens. For her comment, OK, says Claire. He suggests that when Jerome entered the room, there was a discussion about prices for different sexual acts. Claire firmly rejects this. Her prices are set, she's saying, and everything's discussed before the client arrives. He suggests Jerome told her he was ready to have sex and she started removing her lingerie, that there was a conversation about what was going to happen, how much he'd pay. Claire again says no, she always discusses these things beforehand. Then Mr. Dyer puts Jerome's versions of events to Claire. Jerome accepts he stole Claire's money, but at no stage did he grab her around the throat, throw her to the floor, threaten her or her family, put on gloves or produce a handgun. Each and every one of these suggestions Claire rejects. He did. That's not true. He did, she's saying. Instead, says Mr. Dyer, whilst Claire was removing her clothes, Jerome simply went to her handbag, took the money and left. No threats, no gun. Claire's resolute in rejecting all of this. That's not what happened, she insists. Mr. Dyer now takes a different approach to that taken with other complainants so far. With the other complainants, he's chiefly been suggesting that the women have made up the use or the threat of violence because they were angry at having been robbed and, in Hannah's case, raped. With Claire, though, he's focusing on something else. The money that you had on you, he says, the money that you earned through the job that you were doing at the time, do you have to split that money with anybody? No, she says, I don't. Some people in the sex industry have to pay other people, pay third parties, he says. She doesn't, says Claire. She's independent. There's no subtle insinuation. Mr. Dyer's quite explicit in suggesting a motive for Claire fabricating her complaint here. Are you making up this allegation of robbery against this man, against the defendant? No, says Claire, I'm not. Are you doing that to provide an excuse to another party as to why you've lost that money or why that money's gone missing? No, says Claire, I work for myself. Were you scared and anxious about explaining to a third party why you'd just left that amount of money lying in a handbag on the floor that could be accessed by a stranger? No, I was scared and anxious that my family was going to get killed, Claire replies. You've made up the threat of a handgun as a cover for why you were so careless in losing that money. That's not true, says Claire. Mr. Dyer then moves on to ask about her contact with police, that she'd contacted police in City B, who'd subsequently passed her on to a different constabulary, the one covering City A. Did she know why it had been passed over? No, she didn't. Had she ever asked why? She believes it's because there were further cases. That's what she was told. That's what you were told, asks Mr. Dyer. Was she told how many other cases? No. The line of work those women were in? No. Where the attacks happened? No, she says, and I didn't ask. No further questions, says Mr. Dyer. Mr. Palmer's re-examination of Claire is brief but pointed. He's addressing the defence suggestion that Claire might be lying to cover herself with a third party. First, Mr. Palmer establishes that Claire had no knowledge of the other cases before making her statement or her 999 call. She couldn't have tailored her account to match other complainants because she didn't know about them. Then he tackles the defence's core suggestion head-on. She is being accused, he says, of making up her entire account, of lying about what actually happened in that room for her own reasons. I wouldn't have any reasons to lie about that, she says. This is not to embarrass you, says Mr. Palmer. Please don't take it as such, but you lost somewhere between £1,500 and £2,000. Was that a lot of money to you at the time? Not in the line of work she was doing, she says frankly, no. That money represented a day and a half's wages for her. She could have earned it back easily. So what is being suggested here, Mr. Palmer says, is that you, for a day and a half's work, you have invented a handgun and invented a robbery within minutes of the man leaving your room. Have you done that? No, she says. She has no desire to be standing in court, fearing for her child's safety over £1,500. It's a little before 11:15. Claire's evidence is complete. She's been in the witness box for about 25 minutes. DC Sharma, the officer in the case, he's now recalled by Mr. Palmer. Once he's settled on the witness stand, Mr. Palmer tells the judge, "I have no further questions for DC Sharma at this time," and the witness is immediately tendered to the defence for cross-examination. "I'm going to ask you some questions about the sex industry and sex workers," says Mr. Dyer, "because I think it will be useful for the jury." In response to defence counsel's questions, DC Sharma agrees that yes, people working in the sex industry have different roles and work in different ways. Some walk the streets, some work in hotels. There can be a link between sex work and organised crime, and that some women work under the umbrella of a third party. There are criminal offences that cover that, and those third-party relationships can be exploited for gain. That's it. No further questions from Mr. Dyer. Mr. Palmer, however, does now have some further questions for DC Sharma. From your examination of the complainant's phones, was there any evidence that the complainants were being controlled by a third party, he asks. "No," says DC Sharma. "That has been at the back of my mind," he says, "that someone else might be involved, and there was nothing to suggest that." "When you examined the CCTV," says Mr. Palmer, "was there anything there to suggest anyone was close to the hotels in order to control these complainants?" "No," says DC Sharma, "there was nothing like that." No more questions. As DC Sharma leaves the stand, Mr. Palmer turns to the judge. "That is the conclusion of the prosecution's case," he says. The judge now says that the jury's heard that the defendant brandished a handgun, and that when there's an allegation of the use of a firearm, it's added to the charge. It will be added, he continued, and that additional charge will be of an imitation handgun. Another quick aside then. So Jerome's about to be arraigned, formally charged with an offence under Section 18 of the Firearms Offences Act 1968, carrying a firearm with criminal intent. Section 18 provides that it is an offence for a person to have with them a firearm or imitation firearm with intent to commit an indictable offence or to resist arrest or prevent the arrest of another whilst having that firearm or imitation firearm with them. Here, we've got Claire saying Jerome used a handgun in the course of robbing her. Brandishing a handgun constitutes having or carrying a firearm or imitation firearm, and robbery is an indictable offence. The problem for the Crown, however, the prosecution, is that they need to stipulate whether it was a firearm or an imitation firearm on the indictment. And they don't know. The police didn't find a gun. They didn't find a knife either, but they didn't find a gun. So while there's evidence from Claire that Jerome had a gun, there's no way to show whether it was a real or an imitation firearm. Charging Jerome on the basis that he had an imitation firearm then, if the jury's sure there was a gun, they can also be satisfied it was at least an imitation gun. But they couldn't be satisfied that it was a real gun because there's no evidence on that issue. There's nothing that proves it was a real gun. Nothing to prove it wasn't either, but the prosecution has to positively prove each charge so that the jury is sure. So it's a very practical, evidence-driven charging decision, and a conviction for an imitation gun is arguably better than no conviction at all. Quick aside over, although I should point out the jury hasn't had that same little explainer themselves, and that's going to be important later. Anyway, quick aside over, let's get back to court, where the judge is telling the jury a charge for having an imitation firearm is being added to the indictment, and that the matter for them will be whether they believe it exists. The jury is sent out for a quick break while the indictment is revised. Unusually, it really was a short break and we're very soon back in court. The jury's brought back in, Jerome's arraigned, which is a fancy way of saying that the clerk's reading out the new charge in open court, and the defendant's asked to enter a plea. Not guilty, says Jerome. With the prosecution's case now complete and the indictment finalised, it's the defence's turn, and Jerome is going to take the stand. I've got to be honest, I'm surprised by this, but he is. Jerome's going to testify in his own defence. It's nearly 11:20 when Jerome takes the oath and settles into the witness box. Mr. Dyer begins by metaphorically rolling up his sleeves and tackling the dramatic shift that's occurred during this trial up front. That Jerome came to court knowing he faced allegations involving 5 separate women in 5 different locations, robbery and rape charges. When the trial began, Mr. Dyer is saying, the jury was told Jerome's position was simple. That may well have happened to those women, but it wasn't me. But now Jerome's saying something completely different. Yes, he was the man on the CCTV. Yes, he was in those hotel rooms. Yes, he stole from each of the women. But no violence, no threats, no weapons, no rape. Why did you change your defence? Asks Mr. Dyer. At the time, says Jerome, the charges were very serious. And I just thought the easiest option would be to just say it wasn't me, because I didn't want to, by what I was being accused of, just by me saying I was in the room, I'd be guilty for what was alleged to have happened. So you thought it better to say you weren't there at all? Asks Mr. Dyer. Yes, says Jerome. I was just panicking. Mr. Dyer now takes Jerome through each incident, count by count, giving Jerome's version of events the time and space to fully emerge. With Natalie, count 1, Jerome says he went there intending to deceive her into investing money with him, some sort of financial scam involving stocks and shares and money tips. When that didn't work because of language barriers, Jerome says, he simply stole her money when she went to the bathroom to undress. No violence, no threats. With Jade, Jerome says, he was in the area anyway, so he contacted her, went to steal her money. While Jade was in the bathroom preparing for sex, he says, he took the money from her purse. When she came out and saw him with his hand in her bag, she asked him not to take her phone because it had photos of her children on it, and he threw the phone on the bed and left. The pattern continues. With each complainant, Jerome claims the women went to the bathroom to prepare for sexual activity while he rifled through their belongings and stole their money. Simple theft, he insists, no violence whatsoever. For Hannah, the rape complainant, Jerome's account is particularly stark. She was at her laptop when he arrived, he says, sorting out bookings. Her bag was at the end of the bed. While her attention was on the computer, he took her money. When she noticed and asked what he was doing, he just left. No violence, no knife, no rape, no sexual contact at all. Jerome's evidence in chief takes around 40 minutes, give or take a couple of minutes either way. Mr. Palmer, the prosecutor, then takes Jerome straight into cross-examination, and immediately the tone and atmosphere in court shifts. This cross-examination is everything the complainant's cross-examinations were not. It's sustained, it's aggressive, and it's relentless. Prosecuting counsel wastes no time on niceties or settling the witness in. Instead, Mr. Palmer's opening line is, "You accept, on any view, you've lied throughout the course of this investigation." "Sorry," says Jerome. He seems a little taken aback. "Sorry, in what terms have I—" Mr. Palmer cuts him off. "You have lied to one person or another from the moment this investigation started," he says. "At some stage, you admit, do you not?" "Yes," says Jerome, I do." "Why?" asks Mr. Palmer. "Because," says Jerome, "he didn't think he'd be believed if he gave an account. If he told police that yes, he was there, they wouldn't believe he hadn't committed the robberies like the women were saying. So he just denied being there altogether." "You persisted in that lie all the way through my opening to this jury," says Mr. Palmer. "If the CCTV footage had been lost, were you going to persist in saying it wasn't me through the trial?" "No," says Jerome. "When did the penny drop, Jerome, that you needed to say what you needed to say?" "When I knew I had to stand in this box," Jerome says. "Or, like the inveterate gambler that you are," suggests Mr. Palmer, "did you want to see what cards we had, the prosecution, before you committed yourself to what hand you were going to play?" "This is not a table at Winner's Casino, is it?" says Mr. Palmer, "where you can fold when you like and might only lose whatever money the buy-in is. This is a criminal trial, is it not?" Mr. Palmer takes Jerome through all his previous lies, the no-comment interviews, the false defence statements claiming it wasn't him, even at one point naming another person as potentially responsible. Quick explainer, this hasn't really come out in the evidence so far, but at some point, Jerome seems to have told police that he might have used the 2468 and 1357 telephones, but they weren't his phones, they were his friend's phones, and he'd given police that friend's name, although Mr. Palmer questions whether that person even exists. Anyway, back to Mr. Palmer, who for obvious reasons is really pressing on this issue, that Jerome has lied and lied and lied throughout the investigation, up to and including trial. You filed defence statements you knew were lies right up until the morning of trial, Mr. Palmer's saying. Why? Why, when he was first charged, faced with what Jerome himself has called a barrage of serious charges, why didn't he simply tell the police the truth then? You could have said, suggests Mr. Palmer, and that was your opportunity. This is not about a robbery or a rape. I'm a bag snatcher. That is what you are asking us to believe, is it not? That's not what I'm asking you to believe, Jerome protests. Well, what are you asking us to believe then? What are you, fires back Mr. Palmer. Well, at the time, like I told you, I wasn't presented with armed robbery. I was presented with robbery. Mr. Palmer cuts across this. That was a good opportunity, can I respectfully suggest to you, to tell it as you say it was. This is all a terrible misunderstanding. I simply snatched her bag and went. Well, I didn't snatch no bag, Jerome objects. I just went into the bag. He really doesn't like being characterised as a bag snatcher. It's obviously rankling him, which is odd because in essence that is what Jerome's defence is. Anyway, back to Mr. Palmer, who's turning now to the heart of the matter. 5 women have described you, Jerome, as sticking your arm around their throat in a headlock and robbing them of their money. Nothing like that happened, asks Mr. Palmer. Nothing like that happened, agrees Jerome. Can you help us with an explanation as to why 5 women, independent it seems of each other, would want to say that about you? Possibly in a sense of revenge, says Jerome. I don't know. Revenge, says Mr. Palmer, for what? For stealing their money, he says. Mr. Palmer now points to the absurdity of Jerome's position. You accept you are a liar, he says. Are you saying you've just been desperately unlucky 5 times then? Desperately unlucky how? Asks Jerome. Well, let's follow it through, says Mr. Palmer. Your plan for each of these 5 women was to turn up, not engage in sex, and steal their money by hook or by crook. That was the plan, yes, says Jerome. You were lucky in the sense that that plan worked because you went away with differing amounts of money, but each time the plan had come to fruition, says Mr. Palmer. That's correct, agrees Jerome. But unlucky in that each of them, rather than just ignore the fact that they've lost money, £60 in the case of Jade, so unlucky that all 5 women just settle on the fact that this was not a bag snatch, but was a robbery in serious circumstances. That is very unlucky, you must be saying, Jerome, suggests the prosecutor. In terms of that, says Jerome, yes. Mr. Palmer reveals Jerome's gambling debts, £8,500 owed to one casino, £900 to another. Desperate men do desperate things, says the prosecutor. You did desperate things by robbing people of their money, not just stealing it, didn't you? No, says Jerome, I did not rob. Mr. Palmer now sets out the precise timings of the incidents, which he suggests also undermine Jerome's claims. The CCTV footage shows these weren't quick in and out thefts from handbags, he's pointing out. Jerome was in Natalie's room for an hour and a half. He was in Jade's room for 21 minutes, Claire's for 16 minutes, Hannah's for 29 minutes, and he was in Sophie's room for 53 minutes. What was taking so long if you were just grabbing money and leaving? Asks Mr. Palmer. He was trying to find the money, says Jerome. But you knew where the money was, Mr. Palmer's saying, because everyone told you where their money was. Jerome disagrees. No threats, no violence, just rifling through handbags looking for money and then leaving. So they're all lying, Mr. Palmer asks. And Jerome's agreeing that yes, they are, out of revenge for having had their money stolen. Mr. Palmer's particularly interested in count 1, which is the robbery of Natalie. Jerome, as we've just heard, was in Natalie's room for an hour and a half, and she's the only victim that Jerome said he wasn't planning on simply stealing from. He'd gone into her room intending to scam her into giving him her money under some kind of investment ruse. It wasn't especially clear in Jerome's evidence in chief, and I have to say, Mr. Dyer didn't push Jerome too much on it, but Mr. Palmer is. What were your top tips that she should have wisely taken up, he asks. Jerome takes a beat, but eventually says, just invest in, like, stocks and shares. We're all okay here, says Mr. Palmer. What were they? I might want to have a little flutter myself. What was your top tip back then? Buy low and sell high, says Jerome confidently. Buy low and sell high, says Mr. Palmer, and that took an hour and a half to talk about. No, it didn't. Like I said, the language barrier between us, it made things difficult. And not only that, Mr. Palmer interrupts, I expect she understood give me your money with your arm around her throat, he says. That probably transcends many language barriers, does it not, Jerome? Because that's what you did. That is not what I did, says Jerome. Mr. Palmer brings his cross-examination of Jerome to its conclusion by asking, the only liar in these proceedings is you, is it not? No, says Jerome. There are no further questions from either Mr. Dyer or the judge, and Jerome returns to the dock at the back of the court. The judge turns to the jury. That's all the evidence, he tells them. Do not be distracted by any loose ends. Concentrate on the evidence you've seen. You'll be sent home now until tomorrow. Tomorrow you'll hear closing speeches and my summing up. And with that, the jury leaves court. Once they're gone, counsel and the judge start to discuss the necessary directions for the jury. It's Thursday, day 7 of trial. Sort of. The reality is that this trial started over 3 weeks ago, but we've lost so much time along the way for a variety of reasons. Defendant illness, witness no-shows, the defence change. It's difficult to keep track of where we are. It feels almost meaningless to say it's day 7. But technically, that's where we are. There are some last-minute discussions going on between both counsel and the judge regarding the requisite legal directions for the jury. Once everyone's satisfied with what's being covered and how, His Honour rises to finalise his directions and have them printed off for the jury. After maybe an hour or so, the judge is back in court. His Honour tells counsel the directions are done, but he's been sent a jury question which he's going to deal with first. The jury's now brought in and His Honour reads its question to the court. Should the counts with the knife and the gun be classed as armed robbery? The judge explains that there's no offence of armed robbery in English law. There's just robbery, which is defined in Section 8 of the Theft Act 1968. A person is guilty of robbery if he steals and immediately before or at the time of doing so, and in order to do so, he uses force on any person or puts or seeks to put any person in fear of being then and there subjected to force. Where a robbery involves a firearm, as we have in count 3, the incident involving Claire, there's typically an additional charge of carrying a firearm with criminal intent contrary to Section 18 of the Firearms Act 1968. For whatever reason, no Section 18 charge was on the indictment as originally drafted, which, if you remember, the judge queried with the prosecution a few days ago, and a 7th charge has been added to the indictment. Having dealt with the jury question, the judge goes straight into legal directions. Now, I covered judges' directions fairly comprehensively in Tariq's trial back in episodes 1 and 2, and there's a considerable amount of overlap with those directions here, which makes sense because judges aren't reinventing the legal directions wheel each time there's a trial. There's guidance as to what directions need to be given, in what circumstances, and there are specimen or standard directions set out in the Crown Court Compendium that judges adapt to specific facts and issues in a particular trial, rather than drafting from scratch each time. Those directions cover everything from basic legal principles like the burden and standard of proof to specific offence directions and procedural matters, special measures, for example, bad character evidence and so on. One of the purposes of specimen directions is to ensure consistency across courts and to help judges cover all the necessary legal points without inadvertent omissions. Judges will modify the language to fit the particular facts and issues in their case, but the core legal framework remains consistent across the board. Which is a long-winded way of me saying I'm not going to go through all of the judge's directions here in detail because it's standard fare, much of which you've heard before. He begins, as usual, by reiterating that it's the jury's job to decide the facts and to analyse the evidence fairly, that he's going to give them a summary of the evidence, but he says, do not waste a moment of your time trying to work out what my view of the case is, because it really doesn't matter. That's a matter for you. He talks them through the indictment and the different charges. Then he directs them on the burden and standard of proof that the prosecution has to prove guilt so that the jury's sure. He tells them that Jerome admits that he stole from the complainants. If they're sure he used violence, then he's guilty of robbery. If they are not sure, then he's not guilty of robbery, but guilty of theft. His Honour now takes them through the rape charge. He defines each element of the offence and tells the jury that the prosecution doesn't have to prove that the complainant fought Jerome off. Conceding to violence, he says, is not consent, although, as the judge notes, Jerome says sexual intercourse didn't take place. He then gives what's called a cross-admissibility direction. In a case like this, where we've got multiple complainants making similar allegations against an accused, the question arises as to whether the evidence of one complainant, let's say the evidence of Sophie, can be taken into account when considering counts relating to other complainants, so Natalie, Jade, Hannah, Claire, and vice versa. Because Sophie can't tell you what happened to Natalie, Sophie can only tell you what's happened to Sophie. But it stands to reason that if you've got 5 complainants saying the same or at least very similar things, the more likely it is that those accounts are true. The problem with that reasoning, though, is that more isn't necessarily more. If the complainants have all got together and concocted a story, or if they've all spoken to each other and influenced each other's accounts, even entirely unintentionally, then what might look to be mutually corroborative accounts, they aren't. It's a chorus of at worst concocted and at best contaminated evidence. The cross-admissibility direction seeks to address this. His Honour directs the jury that if they're unsure whether the 5 complainants knew about each other's accounts, they must consider each robbery charge separately. In other words, they can't consider the evidence of, say, Sophie when they're considering the counts relating to Claire, and vice versa. However, he tells the jury, if they are satisfied that the accounts were given independently, they may use the similarities between accounts as evidence supporting each individual count. He gives the bad character direction, telling the jury they are entitled to take into account Jerome's previous convictions for robberies of prostitutes and violence to women. It is not, however, proof that he committed these offences, and they must not convict solely or mainly on that basis. There's a hearsay direction relating to Natalie's statement, which was read into evidence because she can't be contacted. That statement contains a statement of truth, but, says the judge, this is not the same as giving evidence under oath. The defence hasn't had the opportunity to cross-examine her, and you do not know how she would have stood up to questioning. Jerome's silence during his police interview, his no-comment interviews, and his later refusal to be interviewed as the investigation uncovered more complainants, that is his right, the jury's told, and shouldn't be held against him. Lies in Jerome's defence statement. His Honour outlines the changing defence and the opposing positions of counsel, the prosecution saying Jerome has simply swapped one lie for another, the defendant saying he thought he wouldn't be believed if he admitted his presence, but knew he'd ultimately have to tell the truth one day. Jerome's lies are not evidence of guilt, says the judge, and he should not be found guilty solely or mainly on that basis. He then gives the jury its route to verdict, which, despite the number of charges, isn't complex. If the jury's sure that Jerome used or threatened violence to take the complainant's money, then he must be found guilty of robbery. If they're not sure, their verdicts must be not guilty of robbery, but guilty of theft. On the rape charge, they must be sure that sexual intercourse occurred, that Hannah was not consenting, and that Jerome didn't reasonably believe she was. The jury is reminded here that Jerome's saying there was no sexual contact. He's not disputing consent. Finally, the judge tells them that if they find Jerome is not guilty of robbery on count 3, then they cannot convict on count 7, the firearms offence. If they do convict on count 3, however, then they must also consider count 7. The judge stops here. As in Tariq's trial, we've got split directions. The judge's summing up and final directions will follow closing speeches. Mr. Palmer now takes to his feet to give the prosecution's closing speech. He begins by emphasising why jury trials exist. You 12 are well equipped to embark on an exercise that you do every day without realising, he says, weighing up what someone says to you and deciding if it makes sense. Are they telling the truth, trying to tell the truth, or fobbing you off with nonsense? The central question, he says, is simple. Have 5 people come to court and perjured themselves, or is the liar closer and sat right there? Mr. Palmer's most powerful argument focuses on the remarkable similarities in the women's accounts. He quotes one of the complainant's testimony. He just came from behind me and squeezed my throat real tight. No sound would come out because of where his arm was. He said in my ear, "Shut up, just shut the fuck up, just stop fucking talking." So in the end, I just did what he told me. He dragged me around. If you get up when I get up, I will hurt you. You'd be forgiven if you can't remember whose words those were, says Mr. Palmer, because that's the words of all of them, isn't it? How, he asks, do 5 women independently come up with the same accounts? Many ways to commit a robbery. A threat is enough, hand in pocket imitating a firearm, a punch, a push. Why do they all settle on the same account? He highlights details the women couldn't have invented. Jim hearing Natalie say, "Why are you doing this to me?" through the door. Claire's immediate 999 call. Hannah's knowledge of local areas only Jerome would know. He points to Jerome's elaborate planning, checking exits, wearing hats, gloves, not touching anything. It doesn't fit with simple theft, Mr. Palmer says. That's the kind of planning for a robbery by a desperate man who needed money. The timeline evidence, he says, also supports the women's accounts of prolonged ordeals, not quick thefts. Their motive isn't revenge, he concludes. It's something far more powerful, the pursuit of justice. The right, just verdicts are guilty verdicts. Mr. Dyer's closing for the defence begins with what to the non-advocate might be an unexpected strategy. He's starting with Jerome's previous convictions, which he's telling the jury now actually help Jerome's defence. That may surprise you, Mr. Dyer says, and the looks on the jurors' faces suggest he's right. That may surprise you, he says. How can previous robberies and violence assist the defence? Because for each and every one of those previous offences, Jerome pleaded guilty, says Mr. Dyer. He's pleaded not guilty throughout this case. He moves then to Jerome's lies throughout the investigation, which Mr. Dyer suggests are understandable when viewed alongside his criminal history. It's understandable when Jerome says he was worried he wouldn't be believed, says Mr. Dyer. Who would believe me if I said I was in the room? And as the charges mounted from 2 complainants to 5, if you believe he buried his head in the sand when it was 2 against 1, where do you think his head goes when it's 5, asks Mr. Dyer. He hides and he's distanced himself because he's never had a trial before. He admitted what he'd done in the past. Jerome has, however, finally done the right thing, Mr. Dyer continues. Jerome's spoken up and said that it was him and he did steal from these women. Mr. Dyer then points to what he describes as anomalies in the prosecution case. If Jerome was a violent predator with a set method, why was there no sexual agenda with 4 of the 5 women? Why was a handgun only used once? Where is the handgun? Jerome explains these anomalies simply, Mr. Dyer says, because it didn't happen. Mr. Dyer questions why experienced sex workers like Jade didn't report immediately if they'd truly suffered violent ordeals. He raises again the lack of injuries despite alleged and prolonged violence, particularly Sophie's photo showing no neck injuries despite claims of a lengthy chokehold. It may be that some people will bruise or redden more than others, he says, but I want you to think about that. Is she telling the truth or is she exaggerating? Remember, an exaggeration is a lie. Other complainants with no injuries, he says. No injuries because Jerome says there was no violence. It's a matter for you. He points out that the judge has given them directions about lies not amounting to guilt. Can you really be sure that these women are telling the truth given the lack of other evidence, he asks pointedly. And while much has been made by the prosecution of the similarity among the complainants' accounts, Mr. Dyer suggests, they are not that similar. He concludes with a couple of pointed questions about the plausibility of the prosecution's case. Is it plausible that he raped one woman and didn't touch any of the others, Mr. Dyer asks. Is it plausible he used a handgun in one incident and not the others? That's the end of the defence closing and the jury is sent out for a short break. After the break, we hear the judges summing up. It's thorough but balanced, taking the jury through all the evidence they've heard. Again, like last time, I'm not going to repeat most of it here. You've just heard all the evidence, but there are a few points worth highlighting. The judge carefully reminds the jury of the chronology of the charges, which complainants reported to police, Natalie, Claire and Sophie, with the others found later through police phone work. He also adverts here to DC Sharma's evidence that none of the complainants was given any details of the other complainants or complaints. He emphasises that supporting witnesses like Jim and Hannah's mother have no independent information beyond what the complainants told them. His Honour speaks to the consistency of individual complainants' testimony and the absence of any evidence that any of the 5 women were working under the control of criminals. Crucially, he reminds the jury that police searches found no weapons, supporting Jerome's denials. He also stresses that Jerome's testimony in his defence must be given fair consideration despite his lies, noting that the defendant says he always pleads guilty and has no previous convictions for sexual offences. The jury is told that it needs to appoint a foreperson, that they're under no time pressure to reach a verdict, and the judge can only accept a unanimous verdict at this time. Finally, he tells them they can review the CCTV or hear Claire's 999 call again if needed. That's it. All done. The jury retires to deliberate. Not long after they've retired, maybe half an hour, there's another jury question. They're confused by the wording of Count 7, the firearms offence. The question asks, if you have a real gun or an imitation gun, is that the same offence? The jury's simply told that there's a criminal offence of having a firearm with intent. If police had recovered a real gun, that would have been reflected in the indictment. In the absence of evidence that it was a real firearm, it's added as an imitation firearm. The question for the jury, though, is not a matter of law, it's a matter of fact. In other words, the jury doesn't need to decide whether the gun was real or not. They just need to decide whether they're sure Jerome did, in fact, brandish a firearm like Claire said he did. 2 hours go by and there's another jury note. This time, the judge doesn't disclose the content of the note to counsel, but, he says, it's the type of note that would lead him to give a majority verdict direction. He calls for the jury to be brought back in, but before they arrive, another note's received. Again, His Honour doesn't disclose the content of the note to counsel, but, he says, it essentially covers the same ground. He tells counsel that he will ask the jury if they've reached a verdict, but that in light of this second note, a majority verdict direction would not be appropriate. At this point, the jury arrives. The judge asks the jury to give any verdicts they've already agreed on, and the clerk stands and addresses the foreperson. Have you agreed unanimous verdicts on all of the counts, he asks. No. The judge then asks, have you agreed a unanimous verdict on any of the counts? Yes. The clerk then reads through each of the counts. Count 1, guilty. Count 2, guilty. Count 3, guilty. Count 4, guilty. Count 5, guilty. Count 6, guilty. Count 7, this is the firearms offence. The foreperson responds that they haven't yet reached a verdict on this charge. The jury's thanked, told to go home and to be back tomorrow morning. The following morning, the jury is given a majority verdict direction, meaning the judge will now accept a verdict on which at least 10 agree. A little later, Jerome's convicted on count 7 by a 10-2 majority. So, there we have it. 7 guilty verdicts, unanimous guilty verdicts on 5 robberies and 1 rape, a majority verdict on the firearms charge. According to the mainstream narrative, this case had everything working against it. 5 sex workers, the wrong kind of victim, and a case that at its core boils down to one person's word against another's. In terms of what happened inside those hotel rooms, Jerome said, simple theft, no violence, no rape. 5 individual women said otherwise, and the jury believed them. Despite them being sex workers, despite the so-called Madonna-whore dichotomy, and despite cross-examination that directly challenged their accounts, their motives, and their credibility. But here's the thing. They weren't challenged because they were sex workers. Did you notice? The defence suggested they'd exaggerated what had happened out of anger at being robbed. With Claire, who was robbed at gunpoint, Mr. Dyer went a step further, suggesting she'd invented her account because she didn't want to explain losing her takings to a third party. Suggestions, by the way, that were obviously rejected by the jury. But not once was it suggested or even insinuated, ladies and gentlemen of the jury, you know how these women earn their living. You can't believe a word they say. If rape myths, gender stereotypes and systemic bias are as powerful as we are told, if juries cannot be trusted to assess evidence fairly and impartially in rape and serious sex offence cases, especially in cases involving sex workers, then Jerome should be walking free right now. But he isn't. Now, the sceptic might say, well, of course Jerome was convicted. You saw the case. If you've got multiple complainants all telling the same or a very similar story, then of course the jury's going to convict. It's not one person's word against another's. It's 5 people's word against another's. And the defendant in this case, Jerome, he's told lie after lie after lie. My response? Well, first, on the rape charge, this was a case of one person's word against another's. Yes, there were 5 witnesses, all describing being robbed in very similar circumstances. But only one was alleging rape. And that, according to Mr. Dyer in his closing speech, was an anomaly in the prosecution's case. If there was a sexual agenda, he'd asked the jury, why was only one of the 5 complainants alleging rape? Likewise, he'd said Claire's allegation that the defendant put a gun to her head. If Jerome had had access to a gun, why hadn't he used it in all the robberies? Another anomaly. And, suggested Mr. Dyer, the anomalies were there because it didn't happen. They are individual lies, he had said, told by individual women for individual reasons. In short, then, don't be fooled by the number of complainants in this trial. Hannah's rape allegation was absolutely a case of one person's word against another's, and the defence said as much, with emphasis. The fact that it was one person's word against another's rather than 5 made Hannah's allegation of rape even less likely to be true. That was the defence suggestion. My second response to the sceptic is that Tariq's trial was also a case of one person's word against another's, and a straightforward one. No forensics, no injuries, no eyewitnesses, and crucially, no additional complainants making similar complaints. And the jury convicted there too. As I said in episode 2, one person's word is enough. But 5 people's word will certainly help. Of course it will. If their accounts are consistent and the witnesses are credible. Which brings us back to where we started, with the Madonna-whore dichotomy and the mainstream claim that the outcome in rape cases isn't a question of evidence, but a question of attitude. And that juries' attitudes, their assessment of the evidence, their deliberations and their verdicts are driven by rape myths and gender stereotypes. Like Tariq's trial, Jerome's trial problematises those claims. Here, the jury looked at the evidence, heard the arguments, and reached what seems to be the only reasonable conclusion, that 5 complainants independently told the police the truth about what happened to them. They were sure that Jerome was guilty, on all counts. Still, the sceptic has a point. 2 rape trials resulting in convictions problematise the mainstream narrative, but they don't prove very much. They might be outliers, flukes, 2 exceptional cases that I stumbled upon by happenstance and that don't reflect how the criminal process typically works in these cases. OK, so let's put that theory to the test. Let's go back to court and watch another rape trial. Another case involving what the mainstream tells us is the wrong kind of rape and the wrong kind of victim. Another trial that, according to the conventional wisdom, shouldn't succeed. Join me in episode 5 for Dean's trial. Do you have questions about what we've covered so far? Any comments, observations, or challenges even that you want to make? Drop me a line at host@criminaljusticeinAction.com. I'd love to hear from you, and your questions might feature in future bonus episodes. That's host@criminaljusticeinAction.com. If you've been affected by any of the issues raised in this episode, please visit our website criminaljusticeinAction.com for information about help and support. Criminal Justice in Action is a Scrutiny Media production, researched, written and presented by Dr. Candida Saunders, edited and produced by Candida Saunders and Gary Saunders, music by Al Yunus Manova.